If a police officer saw you driving, there would be direct evidence that you operated the motor vehicle. If the officer did not see you driving, he can rely on other pieces of evidence that might suggest you were driving. An easy example is if another person saw you driving. That could be brought in as evidence. A 911 call that described your driving behavior and your vehicle might be brought into evidence. But let's talk about cases that might be even more circumstantial. Let's say an officer comes up to you and your car is running but parked in a parking lot or parked along the side of the road. The officer might then use circumstantial evidence to argue that you were operating the motor vehicle. So for instance, if you're on the side of the highway, an officer might say, there's no other way for you to get there but to have been driving. When you're in a parking lot, it becomes more complicated because operation of a motor vehicle in Texas is not defined, but it does mean that you use the vehicle for its intended purpose. Getting into your vehicle on a cold night to turn on the heater is not using it for its intended purpose. On the other hand, if you were driving and just pulled off into a parking lot, that driving was using it for its intended purpose. So circumstantial cases can be made against you even when an officer does not see you driving. And it's important to consult with an attorney to see if that case can be made or if you have a strong argument that disproves your guilt.